Since the federal rules were amended to provide for discovery of electronically stored information, the problem has become one for insurance companies of great magnitude because of the ever-increasing trend to go paperless, so that many companies now have the vast majority of their information stored electronically. This can lead to great problems in the event that insufficient steps are taken to preserve and retrieve information that may be relevant to a lawsuit, and in particular to a bad faith lawsuit. The concept of being unable to locate or losing, so to speak, electronically stored information most often arises within the term spoliation of evidence. Back in 2003 and 2004, there were a series of decisions in a case called Zublocki versus USB Warburg that came from the Southern District of New York, in which a judge issued no less than 5 opinions relating to the standards for searching, preserving, and producing electronically stored information. In particular, electronic mail that the judge had found was intentionally deleted. This has evolved now into a sort of a standard where when a company knows that litigation is a real potential, that the company then issue within the organization what's known as a litigation hold, informing all employees that they are to stop normal destruction or deletion, that they are to identify potentially relevant information and store it, doing things like, for example, turning off the automatic cleanup function in your email box. And then also, in some cases, to preserve backup tapes for the system. This has even run to the potential for personnel changes, where we have courts suggesting that you should anticipate that an employee who leaves might have a laptop that has that information. So it gets down to that level. So you need to have the employees checking their personal, even their home computers in some cases. The federal rules also provide for duties of your counsel. It's important for your counsel to also know your system and what's being done. If the counsel doesn't know, they may be held accountable, and the client as well. There is a case in Georgia where counsel made rather innocent remark stating that backup tapes were probably not relevant. They turned out to be highly relevant, and the defendants and counsel were ordered to pay over $1 million in sanctions to compensate the adverse party for the costs of looking at all these backup tapes. Courts are becoming less and less lenient with either party on discovery, and if consistent noncompliance can result in the dismissal of a claim or defense. There is a situation, another case in the South in Florida, where a federal court, because of consistent noncompliance, failure to store evidence, apparent obvious lack of diligence on an ongoing basis, the judge precluded the plaintiffs from presenting any evidence on a $25 million business interruption claim. This can have some very serious consequences for both sides. You have to always be aware, not only when litigation is filed, but before it's filed and after it's filed, to continue to preserve electronic information.